Welcome to the Law, Your Money, and You. I'm Roberta, Saphire, an attorney in Massachusetts.
And I'm Camille, Barron, a financial coordinator also in Massachusetts. And we have a topic that we've somewhat discussed before, but we've had some requests from viewers. They want to know a little bit more about it. So we have a return guest today.
Good. And I know that the topic is on patent law, and we're welcoming attorney Gary Bloom again. The last time you were here, we talked about mock trials. But the time before that, we talked about patent law, correct me and help me, copyright law, and
trademark law.
And we got a lot of requests to narrow in on all of them, but today we're going to narrow in on patent law.
And let's start with the difference between the three, and then we'll zero in on patent.
Yes.
Sure. So patent law allows you to protect your invention. Copyright allows you to protect your artistic expression whether it's a writing, a song.
Like our books,
like
our
your books.
police officers. Yeah.
And trademark allows you to protect your branding for your business.
Mm-hmm.
Yeah.
Mm-hmm.
So, but looking at patent law allows you to protect your inventive concept. It allows you to keep others from using your idea, and it allows you to monetize your idea.
Okay, so Steve Jobs, I'm assuming, we'll say he invented the iPhone. I'm sure he had a team of people. Is that something that will lend itself to patent?
Yeah, so something like a cell phone is incredibly complex. And there's all sorts of things inside that cell phone which would probably be patented separately.
Mm-hmm.
Lots of the different chips, the battery technology, the case, the shape of the case could be patented as well. There's different types of patents. There are what they call utility patents, which you use to protect your useful invention. There are what they call design patents, which protect the ornamental design of something you've invented. And then there's a third type, which aren't as common, plant patents, if you invent a new type of plant. Plant.
Oh,
green plant.
Oh, a
like
plant?
A flower.
There's a patent on a plant?
You can get a special patent on plants.
You've got to be kidding.
Yeah, you got to be
kid you
kidding.
not.
We're doing you got to be kidding now instead of later. Really, on plants?
Yep.
Do you know of any off the top of your head?
I can't say that I've ever experienced or worked on any
you're not
plant
a botanist.
patent applications, but they do exist.
So let me ask you a question. Old days, there was a certain kind of camera, the SLR, no digital cameras or anything. So would the first digital camera that ever existed, would that in itself lend itself to being patented?
Oh,
Yes.
good question.
So patent law protects.
That's only because I'm looking at cameras right here.
Oh, yeah.
Patent law protects your invention. And your invention can be a completely new idea, or it can be an improvement to an existing idea. So somebody had a patent on the old style camera. Someone, when they invented the digital camera, they were able to get a patent on the digital camera. Even though it's still a camera, it's an improvement on the original old style camera.
Just think about the possibilities. Just phone, not necessarily cell phone technology, but phones, telephone. We had the rotary dial way back in the old ages. Then there was the push button. Then there was the princess phones. Then there was the cordless phones. I mean,
you go way back.
Oh, yes. I'm only going by what my grandparents told me.
Yes.
Yeah.
But I mean, would each one of those, because it's an improvement over the previous technology, be in and of itself patentable?
Each one of those in and of itself would be potentially patentable depending on what happened. There's things you can do to protect your invention to get a patent on it, but there are things you can also do that cause you to lose your ability to get a patent. So the United States has this 1-year window from when you've exposed or publicized or published your idea. It starts a clock ticking, and you have 1 year after you've published your idea to apply for patent. And if you wait more than the 1 year, you're prevented. You're precluded
Go
from getting
back to
patent.
where you said the digital phone or digital whatever it is.
Digital camera in her case.
Digital camera was invented. Does that mean that nobody else can make a digital camera?
So patent law allows you, when you're the patent holder, to prevent others, to exclude others from making, using, selling, or offering to sell your invention. All right? If someone wants to sell their invention, and their invention relies on your invention, they need a license. They need your permission.
Oh, and that's how you will make money.
That's how you make money. So say you've invented the digital camera, and you invented the previous camera. If she wants to make and sell her digital camera, she's still going to need your permission because, odds are good, in a simplified world, let's say that her digital camera needs everything that's in your camera to work. She would need your permission because she couldn't make her digital camera without infringing your patent on the regular camera. I like a simpler term is like the rocking chair, right? Someone got an invention, a patent on a stool. Someone else got an invention on a stool with a back, and they called it a chair. And someone else got an invention for something called a rocking chair, which is a chair with, arcs under the legs. But the person who wants to make that rocking chair, they got to talk to the person who made the regular chair and the person who made the stool, right? Assuming those patents are still in existence and still enforceable. But when you have a patent, it doesn't mean that you can do whatever you want with your invention. It means that you can exclude others from doing what they want with your invention.
Now, I don't know if this applies to patents or not. Prescription drugs, when a prescription drug has a certain amount of time before it goes generic, do they have a patent? Does the manufacturer have a patent on that drug?
So drugs are also very heavily regulated through the Food and Drug Administration, and they have to go through a huge process to be approved by the FDA. But the Patent Office allows for the delays in testing of the drugs, but they would still have patents on their drugs. And while that patent is in force, and the life of a patent can be, depending on when you got the patent, it can be 17 years or 20 years for a regular utility patent. As long as it's in force, they can exclude others from making generics even of their drugs. But I think a lot of times what happens is once the life of the original drug patent is expired, people will start making generics. And then there's no patent to enforce, so anyone can make a generic for the drug once the patent has expired.
But during that period, 15 or 20 years, if there's this phenomenal new drug and it's a brand name at that point, it's patented, chances are it's going to be pretty expensive at that time before it's allowed to be generic. So it will be difficult for the average person in many cases to obtain it.
Oh, so that's why you get generic drugs, because the original people's patent expired on a regular drug? I didn't figure that out.
You can have a license to make a generic before the patent has expired. You could get a license depending on how the drug manufacturer wants to handle the situation. Sometimes people in third world countries that are poor and have no money, maybe the drug company will allow a manufacturer outside the country to manufacture the drug for much less cost. Really is up to the drug company because it's their property.
That's something I never thought of drugs as patented. I don't know.
Well, the only reason I even brought it up is only because the kind of work that I do in healthcare and everything, you see a lot of people who can't afford certain prescriptions, and that sometimes has been the reason because they haven't been allowed to go generic yet.
So how many years is that, or is it the same for everything?
Utility patents are all the same. Nowadays, it's 20 years from the date of filing your application. So you file your app, and then you're protected for 20 years from the filing date, assuming that your app actually issues as a patent. And then when that 20-year period
doesn't
runs
issue right away. Don't they make them wait?
Years. It can take years to
before
get a
they
patent.
tell them it's
So actually, let's just take a step
fair.
back, just to tell the viewers how they could protect their invention. So to protect your invention, you would file a patent application with the United States Patent and Trademark Office. There's a couple types of applications you can file. There's what they call a provisional patent application, and there's something called a non-provisional patent application. The two are different in that, well, they're similar in that both will give a very thorough description of your invention, talk about the background of the area of what they call the art where your invention resides, and then they're going to give a very thorough description of your invention. And so that's where the two overlap. the tricky part, the non-provisional is different than the provisional in a few very important ways. The most important way is that the non-provisional at the end will have at least one or more claims, and the claims, it's a term of art in patent law, the claim is where you actually claim, this is my invention, I claim this. I claim a digital camera that consists of the old style camera and this digital memory for storing the images. And maybe it's got optics to, to
So it's
convert.
your claim, it's not some outsider saying,
No.
oh, this
When
is
in
mine.
the patent application and the non-provisional patent application, the claims, which are at the end, almost at the very end of the patent application, are the most important part of the application, because that's where you're saying, this is my actual invention. Everything else is kind of leading up to the claims. The other thing that's very important is that the provisional application, which is easier to write because it doesn't require the claims at the end, any inventor can write his own provisional patent application, and he can file it himself. It's a great way to save money. Two important things to know is, one, you want to be as thorough as you can, as descriptive as you can in your application so that it covers your entire invention. The other thing to know is that when you file a provisional patent application, it will never actually, by and of itself, give you a patent. It doesn't, that's not what it's meant for. It's meant to almost grab a foothold, a timestamp on your patent application process. It gets you, the clock starts to tick. The United States, the PTO doesn't examine, I'm sorry, I should mention too, to get an actual patent, the Patent and Trademark Office, or the office, does what they call examination. They review what you've submitted as an application, and they decide whether they like it or they don't. They look mostly at your claims, right, because that's the part that you're actually claiming, and they will either approve or reject your claims, because at the end of the day, it's the claims that matter the most for what your actual invention is, or what your inventions
So that can
are.
take over a year.
They can take a long time.
Yeah.
So there's this examination process through which the Patent and Trademark Office will examine your claims, and they'll be back and forth about what you can actually get patented. The provisional application never gets examined, so the provisional application by itself can never get you an actual patent.
What does it get you?
It gets you a window. It gets you a line in the sand that says, I filed on this day, and then you have 12 months after that date, or in some cases 14 months, but that's a recent change in law, but you have 12 months after that date to file a non-provisional application. And then if your non-provisional yields an actual patent, you get the benefit, you have to claim it, but you can claim the benefit of the earlier filing date.
Without making your time limit expire, you get an extra
So
time on
because
it?
you have a year, essentially a year, for the most part, after you file your provisional to file a non-provisional. As long as you file the non-provisional within a year of filing your provisional, and you say my non-provisional is about the same invention as my provisional, and I want to claim the filing date of my provisional, as long as you do that in your non-provisional and you get a patent on your non-provisional, the filing date will be back to the provisional's filing date.
Oh, so you still just get the 20 years, but it started
But then
a
it
year
starts
earlier,
on when you file the
the provisional. Oh, no, provisional.
yeah.
I
The
didn't
first
get
one,
it.
the provisional.
Yeah.
Yeah. Yeah, it seems a little unfair that they make you wait so long.
The thing to understand, though, is when you want to protect your invention,
Yeah, that's what.
there have been recent changes in the patent law, and we used to be in what they call the first to invent. So you could make an invention, and you can keep a lab notebook and document all the things you did, and then someone comes and files an application for the same invention, and you're like, no, wait, I invented it first. You could
yeah.
show all your stuff and say, oh, I invented it first, so I'm entitled to the patent, not you. They changed the law in 2012 with the American Invents Act, and now we're on a first-to-file system. So the first person who files, unless someone else actually steals it, because
Seriously?
before you could invent it on your own, but if you stole it, maybe the person that you stole it from could get it back. But other than that, whoever files first is entitled to the patent. So it's
Boy,
important
you
to
really
file.
keep up with it. I mean, I know you have to, but I mean, that's good. So that's why also, I didn't think we mentioned, but you need a special exam. You don't just pass the bar and become a patent lawyer.
You don't even have
you
to be a lawyer to help people with their patents.
Oh, really?
You need to have a special license from the United States Patent and Trademark Office. To sit for to qualify for the license, you have to pass an exam, and to sit for the exam, you have to have a science or technical background. And once you have that license, if you're not an attorney, then they call you a patent agent, and if you are an attorney, they call you a patent lawyer, or patent attorney.
So you're a patent attorney.
Yes, ma'am.
Oh,
What
that's impressive.
What are some
really.
things that typically would prompt somebody to request a patent? I mean, other than the normal expected things, are some unusual things out there?
There are different reasons why someone might want a patent. For some people, they just want to be able to say, hey, I've got a patent. For other people, patents are worth a lot of money. If you look at big technical corporations, high-tech companies, they have patent portfolios. They might have hundreds or thousands of patents. For them, the value is every extra patent that they can add to their portfolio makes their portfolio stronger. So the value of any one particular patent may not be as important as the entire portfolio in its entirety. But for this sole inventor, the small guy, he might come up with one invention that could make him a millionaire.
How about between countries, Russia and the United States? Inventing the first missile that's going to go to the moon.
So
Notice I think of real subtle things that don't matter.
No, I know that happened. Before
Sure.
before you answer, that Five Guys franchise, or is that the franchise? Somebody moved to Cancun or something and opened a Five Guys there, saying they didn't have it registered with the United, not just the United
it
States.
doesn't sound like a patent issue.
Oh, but the Five Guys closed them up.
That's probably more
It
trademark
was a
and copyright
reciprocal.
infringement.
Oh, see the copyright infringement.
We're going to have a test pretty soon. We're going to have to answer if it's copyright,
Well,
trademark,
I'm
or
pretty
patent.
sure trademark. One of my sons trademarked a game, a beach game.
He was looking actually at a patent on that. I don't know.
Oh,
if
that's a patent. What did I say? Trademark.
trademark.
Oh, I meant patent. Yeah, he patented it.
So he could get a patent on the invention, and then he could market the invention, and he would get a trademark to use during marketing.
Oh, so it's like it's all connected.
Intellectual property is very connected. You know, and you could have, there's a lot of overlap,
So it's all
overlay.
called intellectual property.
Yeah.
That's interesting. But we're talking today about patent.
Yes, ma'am.
So does he have a patent on it?
If he was awarded a patent from the
Yeah, I
Patent and
think he has
Trademark
a
Office,
patent.
then he does, yes.
Well, it sounds like it would be a patent. A game.
Yeah.
So they patent games. Monopoly must be.
That'd probably be both, right? Patent and
but
trademark.
wouldn't their
And a
thing
copyright.
have run out? Wouldn't their patent have run out? Because I played Monopoly as a little kid before TVs were invented.
So you have to remember,
We
though,
had-
right? You might have an idea that's protected by patent, and there's a certain duration for the patent protection. But it may also be protected by copyright and trademark, which can have different protections.
Oh.
Copyright is usually by far the longest protection.
So if somebody's in doubt, what they should do is call us up
Yeah,
to
they
get a
should talk
hold
to
of
the
you
attorney,
because
yeah.
Well, like even with Monopoly, then if it goes electronic, an online version, and that's patentable, I'm
Sure.
sure too, right?
what an online version is different than the regular
It
version.
can be, yeah.
Even though it's exactly the same.
It's possibly presented in a different way.
Isn't that interesting?
So yeah, you could have, I'm sure if you have a board game and an electronic game, the electronic game is going to be considered an improvement over the board game.
But
what's-
how long would you say the Monopoly has a monopoly on the game Monopoly?
Well, I mean, if they had a patent on it, a patent is essentially a monopoly, since you brought up the name of the game.
Can that patent be renewed and get another 50 years, 100 years?
No,
or
you
is
don't
it-
get to renew patents.
Oh, really?
Yep. Once
So
the-
that's why they say when your
Strike while
parents
the iron
made
is
you,
hot.
they threw away the
patent.
The patent.
or the mold,
Right?
whatever. But no, it's true. That's why in patent law, you have a very short life relative to other protections. Copyright, it's 70 years plus
Oh,
the life of the
really?
author. Trademark, it's as long as you use it, right? Trademark, it's all about use. So patent has a limited term. But what's important for the viewers to know is if they want to try and protect their invention, they can file their own provisional, but they just have to make sure that it's thorough because it's never going to get examined. It's never going to be examined by the Patent and Trademark Office, but later on, someday, if you get a real patent and your patent claims the benefit of the filing date of the provisional, and someone brings you to court to litigate on your actual patent, in court they're going to look and say, well, you have this patent, and it claimed the filing date of your provisional did the provisional really justify, were you justified in claiming that filing date? You have to have all the support in the provisional. All the same stuff needs to be in the provisional
Fascinating.
that was in your non-provisional to justify getting the early filing date. The court might say, you wrote a smiley face, and that was your whole provisional patent application, so you don't get that filing date. You're stuck with the filing date when you filed your non-provisional, and maybe your non-provisional filing date isn't good enough, and now you lose.
Well, let me ask you another question. Now, the patent office, there's one patent office for the whole country, right?
There's a
That's in
patent and
where?
trademark offices in Alexandria, Virginia. They're starting to have
Okay.
remote
Where do you bring
locations.
suit?
It depends. Usually wherever the defendant is.
What if the defendant's in Europe?
If the defendant's in Europe, then if it's a out of country
Is there
entity,
reciprocal out of country, isn't there?
you could still possibly bring suit in the U.S. and you'd have to have show that they have some presence in the United States that would justify bringing them into a United States court.
What is it, a federal court or a special patent court? I mean, what?
Patent infringement you would do in federal court.
Or for any federal, like wherever the federal courts are.
They're in every state.
So you could do a mock trial on that too, getting back to it.
How about that situation like international where you have two countries competing with each other? I used the example of Russia and the United States competing to be the first on the moon.
Be like a little Cold War.
And they both, is it feasible one or the other or both would put
So-
a patent on their invention?
So what's interesting is when the laws have changed. In the old days, well, what's important is the state now. If you have an invention that you invented in the United States, in the old days, if someone had invented it outside the United States, you could still get a patent for it. But now, if you have an invention in the United States and it's already shown, it's public knowledge that this invention exists outside of the United States, you can't get a patent on it anymore. Mm-hmm. So if there was a real race to invent, it would truly be a race. And also with some of the new laws, the government has prohibited patenting of certain things such as human organisms. So, you can't get a patent on human cloning. The AIA, the American Invents Act, precludes that. So,
It's
they
against public policy? Is
they
that
feel
what
it's
it is?
against public policy. They don't want people to be able to profit by exploring that technology.
We're almost, you've got to be kidding, we are. And I do this to everybody. I take out one of our books on police officers, our friends. But what's interesting is in between the times that you've been on, there's always some scam out there. So you had said our book can be copyrighted. So you get calls all the time on scams.
So just so you know, just by existing, it's copyrighted. The trick is you have to register it for copyright before you can litigate someone for copyright infringement.
Yeah, so if I get a call, which I did, on somebody who says, oh, I can do this for you and that for you, I know this, and it'll just cost your company, $500, and I'll see that it's really copyrighted and really whatever has to be done. And of course what I said to them was, you've got to be kidding. but it's another one. They have, I should have saved this for a scamming thing, because there's always new scams.
Sure.
Do you know there's a number that is called, it shows on your cell phone from the United States, and I figured out they have this run, like it'll be 0612, then an hour later you get a call from, the same things, 0614, then 0616, and they go in the order. How do you stop it? I got so on my phone, I have 100, over 100 now on the ones, to block the callers. But now my cell phone is saying that my phone storage is used up too much from all these calls. You can't stop them.
I'm surprised that someone hasn't invented, so they have apps on your phone that will allow you to block calls.
Yeah.
So someone, I would expect by now, has invented an app that allows you to block a range of calls.
Oh, good
That's an
point.
idea. Yeah.
And you think that's patented?
Whether
that
it's
a
patented or
patent?
not, I don't know. It could be patentable. I don't know if anyone's
isn't
patented.
it?
All I'm saying is
There you go.
you don't need a patent to invent an app. I'm just saying that there could well be an app. I'd be surprised if there was not an app out there already that
A range
allows you
of
to block a
calls.
range of numbers as compared to just unique numbers.
Interesting. Never would have thought of that. You got to be kidding.
Yeah, you got to be kidding. You ever call up and you think it's one of those calls there, and it turns out it's a call you're waiting for? It's like, oh, sorry, I thought you were one of another scams, and they don't know what you're talking about. They go, and they,
It's easy if you just don't answer them. Like I don't answer.
I
them.
know, but
If
you
I don't know
what
who
happens,
it is,
you
if I don't
like-
know who it is, I don't answer.
Like if you're expecting the repairman, you know,
Oh, well,
you
that-
get that
yeah,
you don't know.
You
get
don't
this,
know.
You get this weird thing.
Do you guys have any other questions about patent law?
No, I think you covered it. Is there any other questions we should have asked but didn't?
Probably, but nothing's coming to me off the top of my head right now.
I think you're very thorough. I think anybody, whoever gets you as an attorney is lucky.
Thank you.
But
Yeah,
you're-
definitely.
You're very, very knowledgeable. You may not realize it, but you do. We try to trap you with these trick questions, but you always seem to
Wiggle my way out.
Yeah, you know what you're talking about. I have this like test that the questions we ask, we know the answers to ahead of time. But you're good. You're very good.
Thank you.
Yeah, thank you for coming.
Thank you for
again.
coming back.
And that's
My
a
pleasure.
good wrap.
Excellent presentation.
Yeah,
and
boy, that went
always
by
learn something.
fast. Yeah, always. Thank you.
Yes, thank you so much.
My pleasure.
And again, we ask our viewers if you have an invention or
Yeah.
you have any questions about things as such, whether it be copywriting or trademark or patent or mock trials, whatever it is.
Yeah.
We have a very brilliant subject matter expert here, and I'm sure that we would be very happy to pass whatever you have in questions along to Gary. Thank you so much. And
pleasure.
to our viewers, we thank you very much for watching. Remember, police officers are our friends. It's spreading like hot fire in a couple of dozen towns now already,
More.
more than that.
And our show is spreading
Our
too.
show is growing
Yeah.
too. Thank you very much for watching, and please let us hear from you if you have questions or ideas, because remember, this is your show. The law,
law,
your money, and
and
you.
you.